In this video, we're going to be covering the federal rules of evidence, more specifically Rule 609. We don't want to do a deep dive into all the federal rules of evidence. And Rule 609, if you're not aware, is impeachment by evidence of a criminal conviction. Even as a practicing trial lawyer, I have to admit that Rule 609 is a mammoth because there are so many different moving parts, there are so many different considerations, and there are so many different tests that may apply to your specific fact pattern. So whether you're a law student preparing for an upcoming exam or you're a lawyer preparing for an upcoming trial, if you're struggling with Rule 609, don't worry, you're not alone, and also don't worry, this video is here for you. More specifically, this video is going to provide you with a Rule 609 flowchart. That way you can go through this flowchart and ultimately determine whether or not the evidence in your specific situation is admissible. Now, one thing that I do want to mention before we dive in is that the remaining portion of this YouTube video was recorded for the sole purpose of being a lesson on Trial Ad Academy. And as I was recording the video, I realized that I think my YouTube audience would find this to be extremely helpful, especially because a lot of y'all are law students. So yes, this means that this introduction you're watching right now was actually recorded last, and everything you're about to watch up in the future was recorded in the past. It's a little confusing, but I think that made sense. Now, this long-winded introduction is meant to lead up to a single point, which is that whenever you're watching this video and you hear me refer to the flowchart as a downloadable document, that is being simply referred to all the Trial Ad Academy members who have exclusive access to certain perks and certain downloads. One of those downloads is that downloadable flowchart. So without further ado, let's dive in. Rule 609 is a monster, but you need to keep in mind that before you go down that 609 rabbit hole, that there's a question you need to be asking initially. So let's get a little oriented here. Before we can talk about Rule 609 and witnesses, we need to first look at Rule 404 because that particular rule involves character evidence. Specifically, it prohibits character evidence from being admitted, but with some exceptions. And the relevant exception here is 404A3, which specifically allows for character evidence under Rule 609 to be admitted if the person it's being admitted towards or against, however you want to put it, is a witness. This means that before you go down the Rule 609 rabbit hole, you first need to determine whether or not the person you're trying to impeach with a criminal conviction is in fact a witness. The last thing you want in life, you do not want to have this burden, is to go down the Rule 609 rabbit hole and not having needed to do that because that person wasn't a witness and you weren't able to satisfy Rule 404A3. So just for the sake of the argument, let's go ahead and assume that the person is not a witness. If that ends up happening, you can stop this lesson and just move on with the rest of your life. But if they are a witness, then you dive into the Rule 609 analysis. And to do that, let's go ahead and start looking at the flowchart. My quick rant about Rule 609 is that it wasn't drafted and it wasn't written in a way to where it makes determining admissibility super easy. And what I mean by that is you don't really start from the top and by the time you make your way down all the way to the bottom, have an easy answer on whether or not the evidence is going to be admissible. And as you'll see with the flowchart, we're going to have to jump up and down, back and forth a couple times to determine whether or not the evidence is admissible. Now, there's something worth noting before getting into this flowchart, and it's something that I don't want you to overlook because it's extremely important. If you think the other side is going to try and impeach your witness or witnesses with criminal convictions, then I highly and strongly recommend that you put those issues in a motion in limine and you present those issues to the court before your trial. By filing a motion to eliminate in regards to these issues, there are going to be two primary benefits. First, the response that the other side makes to the motion to eliminate should give you enough of a heads up to prepare your 609 objection, and that way you can basically argue the flowchart we're going to be discussing in this video. Second, by having a motion to eliminate in place, that will hopefully ensure that the other side asks for the jury to be excused so the court can hear outside the presence of the jury the 609 arguments and the 609 analysis. And if you're not too familiar with how motions in limine work, or you're just not familiar with the concept, then be sure to go check out that lesson. And in that lesson, you'll see a download to a pretty standard motion in limine that you can use and apply and tweak and alter to your specific case. Now, on the flip side, if you're looking at Rule 609 to determine if you can get this criminal conviction in and use it to impeach the witness, then there's something you really need to consider. The question is really whether or not you need to present to the jury these criminal convictions. And as we go through the flowchart, you'll see what I mean. Because at certain points in this flowchart, in 609, the judge is going to have to conduct a factual analysis. And every time a factual analysis is conducted, there's always the chance that the other side will try and appeal that decision. And so whenever you have that factual analysis, you're increasing the risk of appeal. And so if you can win the case without the criminal conviction, then you take away another route for the other side to appeal. But the problem and the risk you run is if you end up losing, then you didn't really present the full case, and it's something you're gonna have to live with and something you're potentially gonna have to explain to your client. So again, you're gonna have to strategize on which route you need to take. With those considerations aside, let's go ahead and lay a quick foundation to the flowchart. I know you just want me to dive into the flowchart and I'm just teasing it, but I want this flowchart to be ultra clear to you. I want it to make absolute sense. So to do this, I need to provide a bit of perspective. This flowchart has 2 levels to it. It's like a video game. You have to go through the first level in order to get to the second level. This first level is 609A. And if you can survive Rule 609A, that's gonna take us to level number 2, which is 609B. This means that if the evidence survives Rule 609A, that doesn't mean it is automatically admissible. Instead, it also needs to survive Rule 609B. With all that said, go ahead and download the flowchart, and what you'll see at the very top is the threshold question, which is whether or not you're trying to impeach the witness with a criminal conviction. Meaning that if you're trying to impeach somebody with a criminal allegation, criminal charge, or criminal arrest, then that's not going to apply under Rule 609. Instead, Rule 609 is narrowly tailored to convictions. So if there is no conviction involved, then your analysis is done. Go ahead and stop this lesson. Do not pass go. Go straight, not straight to jail. That's a little bit too on the nose for this conversation. But if the answer is yes, then there are 2 exceptions that you need to consider in your analysis before moving forward. So even if you technically have a conviction at play that you're trying to impeach, Rule 609C and Rule 609E are exceptions to that, to where it turns that conviction into something that doesn't apply to Rule 609. But let's go ahead and assume that those exceptions do not apply, and let's move on with the analysis. The next question is whether or not Rule 609A2 applies, and this involves a criminal conviction involving dishonesty. Now, what I do want to point out is the fact that Rule 609A2 involves any crime, whether it's a misdemeanor or a felony. As you'll see, Rule 609A1 involves typically a felony. It's a crime punishable by death or a crime involving more than 1 year. The reason why we're talking about A2 first is because you have a broader scope. Any crime, as long as it involves the element of dishonesty to some degree. So if the answer is yes here, if there is that dishonest element, then you're basically done with your analysis and it's time to move on to level 2 and determining whether or not this conviction is stale. On the other hand, if the answer is no, if there isn't that dishonest element, then you go ahead and move on to the next question. But before moving on to the next question, let's go ahead and flesh out the policy here so everything makes ultra sense. When it comes to Rule 609A2, it's all about that dishonest element, that dishonest crime. This is basically going to be your easiest standard to achieve if you can check off the boxes. Keeping in mind that the reason why you're impeaching a witness, why you impeach any witness, is to show to the jury that this witness shouldn't be trusted because the witness isn't credible and it isn't trustworthy. That goes hand in hand with a dishonest conviction. But on the other hand, if you don't have that dishonest element with the conviction you're trying to use, again, that does take you to the next question, but it's also why the next series of questions in this flowchart involves a factual analysis that the court is ultimately going to have to rule on, because in this situation, if there is no dishonest element, you basically have what I'll just call an honest crime at hand, and you have to determine whether or not that honest crime should ultimately be presented to, basically test and scrutinize the trustworthiness of the particular witness. Hope that puts in perspective what we're trying to achieve here and why things are going to get a little bit more complicated as we proceed through this flowchart. If there is no dishonest element, that takes us to Rule 609A1, which involves convictions that are punishable by death or by imprisonment for more than 1 year. So the question is whether or not that applies, and if the answer is no, you can go ahead and click this video and move on with your life and go and enjoy your life, because the evidence of the conviction is not admissible. Okay, so let's go ahead and hit the pause button very briefly, and if you can't tell, this is Jarrett from the future, who's about 15 minutes older, who's inserting himself in this YouTube video to say this. If you're finding this video helpful, be sure to hit that like button down below. I think it's over there. And the reason for that is with more likes, the video continues to rank higher and higher and ultimately help more people with its higher ranking. And that's always the goal. And if you haven't hit that subscribe button yet, that's over there as well. And finally, be sure to check out Trial Ad Academy. And for those that don't know, Trial Ad Academy is my online course devoted to giving you the skills necessary to go conquer the courtroom. It's a lot like these YouTube videos, but on steroids, because in Trial Ad Academy, we do a deep dive into every step, every stage of the jury trial process, and it helps you design and implement your game plan so you can kill it on game day. And the beauty of it, there are free updates, you have lifetime access, and you can take it at your own pace. If you're interested, then go in the description down below and click the link to check out more information. On the other hand, if the answer is yes, then the question is going to be whether or not you're trying to use this conviction in a civil case, or if you're trying to use this conviction in a criminal case where the witness is not the defendant. And the rule that we're applying here is Rule 609A1A. If the answer is no, then that means that you're in a criminal case where the witness is the defendant. And in that situation, you have to apply what I like to call the reverse baby 403. And if you aren't familiar with Rule 403, then no worries. I'll go ahead and link you to my YouTube video involving Rule 403. And the reason why it's a reverse 403 is because it essentially flips the standard. You have to show that the probative value of the evidence outweighs its prejudicial effect. And the reason why I say it's a reverse baby 403 is because unlike 403, where you have to show substantially outweighs, in this situation under Rule 609A1B, what you're having to prove is that it simply outweighs the prejudicial effect here. Meaning essentially that you just have to show right over that 50% is outweighed by the probative value. So let's go ahead and just exhaust this path. If the evidence does not survive the reverse baby 403, then that means the evidence is not admissible, and it also means you can just go enjoy your life. If the evidence does survive the reverse baby 403, then it's time to take that evidence up to level 2. Now let's go back a couple steps and assume that the witness is in a civil case or that the witness in a criminal case is not the defendant. At this point, the question is whether or not the evidence survives a traditional 403. Now this is a very important distinction to make. With this particular route and using a traditional 403, there's almost a presumption that the evidence is admissible. The reason for that is because a traditional 403 is trying to keep evidence out. Because with a 403, you're essentially arguing that the probative value is substantially outweighed by the unfairly prejudicial effect. So to simplify, your traditional is basically show me what's wrong with this evidence and why I should keep it out. And your reverse baby 403 is, okay, show me that this conviction deserves to be introduced. If the conviction does not survive a Rule 403, then it's inadmissible. Go enjoy your life. If the conviction does survive Rule 403, then you have to level up and go to level 2. Level 2 is doing an analysis under Rule 609B. The question is whether or not the conviction occurred more than 10 years ago. If the answer is no, then the conviction is admissible. If the answer is yes, then things are much harder, like any video game where you go to the next level, because what you're going to have to satisfy is a reverse 403. And keep in mind, with a reverse 403, there's the substantially outweighs factor. So essentially what you're having to prove is that the probative value substantially outweighs the unfairly prejudicial effect. Let's get a bit nerdy by talking about a situation that most likely will never happen in your career, but it's something to consider, and I think it really helps kind of flush out this entire process. Let's say the judge says, let's go ahead and skip to level 2, 609B. and you have a conviction involving something that was over 10 years ago, and the conviction's crime, well, it didn't have the dishonesty element. That's our situation. And the judge determines, yeah, it doesn't survive the reverse 403, no need to analyze under level 1. Well, in that case, it's pretty simple. You just go ahead and move on. But if the judge says, yeah, this does survive Rule 403 or the reverse Rule 403, then if you're trying to keep that evidence out, then you need to urge and argue level 1, because there may be situations, let's say it's just a traffic violation of sorts. So it isn't a crime punishable by death, and the sentencing or imprisonment is under 1 year, and there's no element of dishonesty, so it wouldn't survive level 1. In that situation, make that argument after the judge has ruled against you on level 2, and that way you can hopefully keep the evidence out. It's going to be pretty uncommon, I think, for you to have to take that approach of going 2 to level 1, but the technical aspect here is that there may be some situations, how few and unlikely they are, I don't know, but there may be some situations where certain pieces of evidence involving those convictions may have to undergo 2 different types of 403 analyses. I think it's pronounced analyses. So level 1, you may have your 403 analysis of some sort, and level 2, you may have this reverse 403 analysis as well. Now, again, be flexible. If the judge wants to skip to level 2, go ahead and do that, but also know that you may have the ability to go back to level 1. Let's go ahead and put that to the back burner and move on. If the evidence doesn't survive the reverse 403, then it is inadmissible. But if it does, then you move on to the next step. The question here is whether or not Rule 609B2 is satisfied, and that involves a written notice requirement. If the answer is yes, then the conviction is admissible. If the answer is no, then the conviction is not admissible. Now, a slight caveat is for you to go check out Rule 609D, which involves juvenile adjudications, which is an absolute mouthful. But just check that out. That's going to apply to very few cases, but it may apply to yours. So just be sure to be familiar with that particular rule. Okay, so this sums up 609. Just keep in mind, whenever you do make your arguments under 403, you want to emphasize to the court why maybe something satisfies the reverse 403, the traditional 403, or the reverse baby 403, or it doesn't. And that requires you to prepare in advance. So I recommend that you do so, and you can use this flowchart whenever you do prepare. But if you have any questions, let me know in the comment section down below. Get your free flowchart in the description. And as always, there's more extra details in the description. And if you don't have any questions, comments, or concerns, I'll go ahead and see you in the next lesson.